Welcome to the Liberty Block podcast with Alu Axelman. I have another installment today of the series of my very basic Supreme Court case explanations. I do this from time to time when I cannot find anywhere on YouTube or other video sites an explanation of a Supreme Court case that I'm interested in. So I'll read up on it, I'll listen to the oral arguments if available, and I'll read the Supreme Court decision, and then I'll make my own video. That way the next person can watch my video and get a basic recap of the basics of the case and the holding in 5, 10, 20 minutes instead of having to read the entire case and listen to the hour-long oral arguments. So I'm doing this as I prepare my book, as I finish drafting my book, The Muzzled Amendment. That's the working title. All about the First Amendment. I'm explaining around 2,000 Supreme Court cases, 1,500 to 2,000 it seems like, throughout the book. And I'm reading all these interesting Supreme Court cases. So anyway, without further ado, today's case is Air Wisconsin Airlines Corporation versus Hoeper in 2014. It was a Supreme Court case that reversed a Colorado Supreme Court case. Kind of gets into the weeds, but I'm going to try to explain it as simply as possible without getting into all of the most complicated elements of the case, because it is rather complicated. It deals with a lot of stuff, but it's a defamation case. A former pilot sued his former employer, which is Air Wisconsin, which is an airline, for defamation and damages that he suffered from that. And the case is going to revolve around whether the airline is immune under a certain federal law that granted them total immunity from even being sued. So it's kind of complicated, but it's not even about the merits of the lawsuit, I don't think. It's about immunity, kind of like the cases I've discussed, I believe, with qualified immunity. It's not even about the merits of whether the lawsuit should have been decided in favor of one or the other parties, the plaintiff or defendant, but it's about whether you could even get into the courthouse to sue them, or whether there's immunity due to a law or court precedent in the case of qualified immunity. So the facts of the case, according to the court records, are thus. A pilot named Hoeper was flying for Air Wisconsin Airlines. He was testing to fly their new aircraft. They were phasing out older aircraft, and he was testing, and apparently he failed 3 times. They gave him one final chance to learn in the flight simulator and pass the tests to be able to fly the new airplanes that they were going to be using, and he was doing poorly, and seemingly he failed that as well. He seemingly had an outburst. He responded angrily, according to the court record, through his headset. He started cursing out and making accusations against the instructor. And later, somewhere else in the facility, this is in Virginia, I believe, in the training center. And I believe he lived in Colorado. So in the Virginia training center, he had this outburst and he started cursing. Now, he was a pilot, and I believe even more than that, he had an extra certification of some kind, I believe, called the FFDO, Federal Flight Deck Officer. He was permitted to carry a firearm while engaged in providing air transportation, and this is a federal law. So I think maybe all or maybe some pilots are allowed to carry firearms, which makes sense. It's a good thing. If you go through all the training and you're trusted to be a pilot to fly an airplane with hundreds of passengers, it's probably likely that you're trusted to carry a firearm in case of hijackers or something. So he was authorized to carry a pistol. So there's that. Now we have an angry person. He's a pilot. He's a disgruntled employee who it seems like everyone knew he was going to get fired because he could not fly his airplanes anymore. He was not qualified. He couldn't pass the tests. So he was about to get terminated. So we have an angry employee. He's about to get fired. He might have a gun on him because he's kind of authorized to carry them while flying, although the federal law only protects them while engaged in flying. So if he's a passenger, he can't, seemingly, but if he's a pilot, he can carry. Now, there's another federal law. So the Air Wisconsin employees, so they booked him a flight back home, I believe from Virginia to Colorado. And they said, all right, go home, and they're going to fire him. And they're sending him home from the training facility because he couldn't pass. As they booked him a flight home, some Air Wisconsin employees called the TSA, the Transportation Security Administration, and they warned them that there was an FFDO who may be armed, and that the airline was concerned about his mental stability and the whereabouts of his firearm. And they said during the phone conversation that an unstable pilot in the FFDO program was terminated today. For what it's worth, I don't think he was terminated yet, but everyone kind of knew that it was imminent. TSA removed Hoeper, and they took him off the plane, searched him, questioned him about the location of the gun, and he had to go through that, so I guess he missed his flight, and so he went through some suffering, and obviously it's kind of humiliating. So he's sued for defamation, and in Colorado, which I believe is his hometown, the state court jury ruled in his favor, and the Colorado Supreme Court affirmed. Now, the Air Wisconsin appealed to the U.S. Supreme Court from the Colorado Supreme Court, and they made the argument that a certain federal law totally shields anyone, airline employees, from defamation liability. So I'm honestly not 100% sure if it's the same as like a total categorical immunity from being sued, or it's liability, like a kind of defense, being shielded from liability if the disclosure was made with general truth. So it's obviously if the defamation or if the statements were made that were accurate or at least in good faith, pretty much the airlines and their employees have immunity from reporting suspicious behavior, except where such disclosure is made with, quote, actual knowledge that the disclosure was false, inaccurate, or misleading, or made with reckless disregard as to the truth or falsity of that disclosure. So, generally, as long as they're pretty much telling the truth, these airline employees who are concerned are protected from being sued for defamation. Now, the jury did find for Hoeper, so that I think that's an important thing. It's not in this case, they weren't blocked from being sued. In the initial lawsuit, the jury did rule in favor of Hoeper, agreeing that he was defamed by the airline. Now, the airline employees, obviously, this law was passed, so I'll give you the name of the law. It was called the Aviation and Transportation Security Act, ATSA. And if you listen to the oral arguments that I'll link here, they refer to it as ATSA. So ATSA, but the lawyers, they say very quickly ATSA. So that's just what they're talking about if you hear them say that, ATSA. That's the law that protects the airline employees and those kinds of people from being sued, and it gives them some leeway so that they're encouraged to report, and it makes sense. The whole see something, say something kind of concept. They encourage them to report suspicious activity that could affect flight safety. Obviously, they want to err on the side of caution with TSA when dealing with potential threats that are flying in the air. So, pretty much, the case, if you listen to oral arguments, the lawyers argue a few different points about whether the falsity or recklessness as to the falsity or truth of the statements, whether that's material, whether that's even involved in the case to be decided by the court, whether that's a question for the court. They I think an interesting question that kind of gets to the heart of it is, from what I heard in the oral arguments, is whether the truth, the veracity of the statement, how true or false it was, whether that's a question for the judge or the jury in the case. And I think that's a great question, because I'm not sure what to do with that even, because I could see both ways. I think I would err on the side of the jury. If they're deciding it, they should determine whether they're liable. Again, this is an interesting case because it kind of is about whether they could be sued at all, but it's also about whether, if the lawsuit's happening, whether they should be liable because of the statements were false. I don't know personally how I feel about it. I see a few sides, a few arguments here. The statements, I think the lawyers from both sides seem to say, and the Supreme Court justices seem to say, they could have made that report a little better, because they said he was mentally unstable. I don't think had evidence of that. I think he just had an outburst, which not great, but also not the worst thing ever. People have lost their temper before, and losing temper and cursing and even throwing a headset does not really mean that they're likely to take their gun and start shooting people in the airplane. On the other hand, saying mentally unstable or possibly suspicious or maybe mentally unstable and disgruntled employee, like the airline employees told to the TSA, it's not that much of a stretch. Should they be immune from liability? I don't know. So the Supreme Court reversed the Colorado Supreme Court and held that the ATSA immunity may not be denied to materially true statements. So they held the statements were pretty much true and not pretty much false. So I'll link to the case summary and the whole case. It's like the entire decision text on Justia, and I'll link to the oral arguments as well on oyez.com and maybe on YouTube. Let me see if there's anything else here. Yeah, the Supreme Court just said, under the correct material falsity analysis, Air Wisconsin is entitled to immunity as a matter of law. It's kind of interesting. They bring up the Times versus Sullivan that I didn't do a video on, because I'm sure there are a million videos on it. It's like one of the canonical cases of defamation in history. That's where it was determined by the court that for public figures, if a public figure wants to sue for defamation, he has to prove a little bit higher standard for defamation to win. He has to prove that there was actual malice in the statements made that were defamatory by the defendant. So they kind of talk about that, and it's a similar kind of standard of it's a little above and beyond the general falsity, the general like common law standards for defamation lawsuits. So this was interesting. Colorado, the trial court and the Supreme Court held one way, and then the U.S. Supreme Court reversed that. Let me see exactly what the breakdown was of the court. So Oyez and Justia are seemingly sister sites. They link to each other. And let me see. It gives a good breakdown here. Yeah, it says unanimous decision. There might have been another concurrent opinion, but it was a unanimous decision according to Justia. So I can't share the screen, I'm on a Zoom, but I'll link to here to all this. The Oyez summary, I'll read it real quick. The questions posed to the court were: must a trial court decide whether the ATSA grants immunity to a party before trial? So yeah, it's one of the things, like I was saying earlier, is whether this is like an absolute immunity from lawsuit, from being sued, or is this like a kind of defense that is raised at trial? So hopefully I'm explaining that correctly. The second question is, does the free speech clause of the First Amendment require a court to independently examine the record when reviewing a defamation case? And the conclusion was no. Justice Sotomayor delivered the opinion for the 6-3 majority. That's what it says on Oyez, even though it said it was unanimous on top. The court held that ATSA immunity protects false statements as long as they are not materially false within the ATSA context, which means that they would not affect a reasonable security officer's perception of and response to a particular threat. Although Air Wisconsin's report to the TSA contains slight inaccuracies, they would not have influenced a TSA security officer's desire to investigate Hoeper, given the true facts that he was an FFDO and upset about losing his job. Interesting. The court further held that the Colorado Supreme Court made a mistake in its analysis of material falsity and that Air Wisconsin was entitled to ATSA immunity as a matter of law. Justice Scalia wrote an opinion concurring in part and dissenting in part, in which he argued that while he agreed with the majority's opinion that ATSA immunity analysis, he would have remanded the case for further proceedings. He argued that the issue of material falsity was an important question for the jury, and that a reasonable jury could find that Hoeper's conduct did not justify the making of any report to the TSA. Clarence Thomas and Kagan joined in the opinion concurring in part and dissenting in part. Okay, so 3 of them, so it's not really unanimous. I'm going to write for my book that this was 6-3 because 3 of them wanted to remand the case. So in the Supreme Court, there are a few things that can happen. Sometimes they can totally reverse a decision, and seemingly that's the end of it. If it's a conviction, it would be called vacated or something, or reversed, and then the person is free. This is a civil lawsuit for defamation. Sometimes they can reverse it, but I think often they remand it, meaning send back down to the lower court because there was a mistake. According to the Supreme Court, they made a mistake, some kind of matter of law mistake the judge made. I was going to say, like I mentioned to earlier, the jury can decide this. So is this something the jury can decide, whether it was false, whether it was appropriate to make that kind of report, whether the statements of mentally unstable or whatever was appropriate? I think in general, the presumption should be that these are questions for the jury, as opposed to questions for the judge, in which he might block the case from even entering the court, so it can't be heard. So Scalia and Thomas and Kagan did believe that this case should have been remanded back so that maybe the judge, in the case again, it would be another trial, the judge would tell the jury all these things and give different jury instructions for them and explain to them the issue of material falsity was to be determined by the jury. So I think I probably lean toward that opinion. So this, by these 3, the minority opinion, the dissent. So that's the case. Please comment below if you have any thoughts, if I could have explained it better, if you still have any confusion about it. I try to make it simple enough to understand all of the important holdings in the case. And remember, this is not general defamation. This is only defamation under the ATSA context, the Aviation and Transportation Security Act. It gives special statutory immunity in a certain context to like airline employees and security employees and stuff for airlines. So in a sense, it's a narrow ruling because it only at all controls this narrow context, and it affirms, the Supreme Court 6-3 affirmed that airline employees should be encouraged to report potentially suspicious activity as long as, in good faith, they're saying what they're saying is pretty true to the TSA, and continues to encourage them to not be afraid to report things, even if it turns out they're wrong, as long as they didn't make a huge mistake by saying, by falsely telling and knowing it was false, to tell the TSA, hey, Alu is really ugly, and therefore we're going to tell the TSA he's so ugly, he's dangerous, you can't let him fly, and then they pull me off the airplane. If they do that, then they might be liable. But yeah, it's interesting. I personally think it's interesting because this discusses the unique area of whether or not a case could even get into the courtroom, because I discussed it a lot with qualified immunity, where even if a cop very clearly, tortures and shoots people and assaults people, rapes women, something like that, sometimes on the facts of the case that are like not even disputed by either party, it's clear that the cop would be liable. Like, it's clear to any reasonable person from this universe. But because of qualified immunity, it's a certain doctrine that I'll get into in a different video maybe, or I've probably done it in the past. They can't even get into the courthouse. They can't even sue. So it's not even about the merits of the case, of what happened. They can have video evidence, but because of a certain thing, the Supreme Court ruled that unless it was a clearly established constitutional right that was violated by the Supreme Court, that they established in a prior case, the cop can't be sued for that even. So that's the case. It's about whether there could be liability, whether the case can go to trial, and if it can go to trial, is this a determination by the judge or jury about the ATSA immunity. So this one, there were some similar cases, and I might do videos on them as well. I'm glad I wrapped this up in under 30 minutes. I'm usually very long-winded, and these videos take longer, so I'll post it as a podcast and video. Thank you so much. Check out libertyblock.com and aluaxelman.com if you have time. Follow me on X at libertyblock and at aluaxelman, and I'll keep working on the book. The working title is The Muzzled Amendment, and it might be coming out this summer or fall. Stay tuned. It's going to be the biggest, most comprehensive book on all First Amendment stuff in the universe, and it's going to be awesome. Thank you so much for listening and watching, and have a great day.